So as we go through this entire structure, we're going to test everything we talk about against these four criteria. So what are the tools? What are we actually doing for them? These are the three tools that primarily we're going to focus on. There can be others, but for the purposes of this, I think these are the three main ones. These probably cover 90% of all the things that asset protection really involves. So these are definitely the main ones. So limited liability companies, which I'm sure many of you already have in place. Asset management limited partnership, which is just my term for a limited partnership. That's similar to the syndication structures that I referred to earlier. That's similar to a family limited partnership, which many of you might have heard of, the family limited partnership. And so it is a very, very good tool. And then the third thing is the asset protection trust. And this is where we'll spend most of the time. This is where most people know the least and are the most confused or the most unaware of what can be done, how it can be done, and I'm sure there'll be a lot of questions on that. So let's start with the LLC. So limited liability company is just that. It's a company which limits the liability of the members. That's its purpose. So it's great for what we call risky assets. And risky assets are assets that can create risk. So for example, a risky asset would be your house, a rental property, a car, an airplane, a boat, a business, anything where you have a key, a lock, a propeller, an engine, a door, any physical asset that can end up hurting somebody in some way or another. The most common is going to be a piece of real estate. That's what you're going to see most often. But if you have an airplane, it should also be in its own LLC. If you have an expensive boat, it should also be in its own LLC. If you are going to start other companies that are unrelated to your primary business, which I know many of the DSPs do, which I think is very interesting that many of the DSPs have many other businesses, not even related to the DSP model, but other things that are, iFixit stores or other models. Separate LLCs create separate baskets so that we can isolate risk. And that's the point. We want to segregate the assets. When you put everything in one basket, then if that basket catches on fire, everything in the basket is at risk. And so our goal with LLCs, since they're very easy, and you'll see from a tax standpoint, by using the structure of layering, we can make the management of the LLCs actually very simple and keep them disregarded and not have extra tax returns that we don't need. The way in which an LLC protects is what's called charging order protection. And what that means is that you can't just break into an LLC and grab the assets and distribute them. That would be called foreclosing on the company and distributing the assets. With limited liability companies, under the statutes in which they're written, that's one of the things that they were preventing, is a creditor reaching into it. In order to provide a remedy for a creditor, which they still needed to do, the states that drafted these statutes said, well, we can't leave the creditors out, we got to give them a remedy. They gave them a remedy called a charging order. And what a charging order is it's basically a lien against your interest in the LLC. So if you're a 50% member in an LLC that invests in a portfolio of real estate and you have a judgment against you, that creditor could get a charge against your interest, but they cannot force a distribution of the underlying assets, and that means you can basically hold them off. And that's exactly what happened in the story that happened with my father and his investors, because a limited partnership has the exact same type of protection, which is charging order protection. It's a very nice level of protection. It does a good job. Asset management limited partnership, very similar in legal structure, but in my opinion, and when I look at it and the way I use it, it's even better, especially at the holding company level. And we will put this all together, so it will make sense. You don't have to get it all this first 10 minutes. But what it holds is the LLCs. So if you've got a bunch of LLCs and various assets, investment real estate, your other businesses, etc., and we layer them up into a holding company, now we have 2 layers of charging order protection. And that's very good. And this is also an opportunity for you to choose a different jurisdiction than the jurisdiction of the LLCs. When you set up an LLC, for example, to hold a piece of real estate, a lot of people will ask me, well, I've heard Wyoming or Nevada or Delaware has really good LLC laws. Should I use an LLC in that state? And my first question is, well, where's the real estate? And if the answer is, oh, it's in California, then I say, well, if you set up a Wyoming LLC, which is totally fine and legal, and then you import it to California and you have it own California real estate, you're going to have to register that Wyoming LLC to do business in California. You're going to have to pay the franchise tax in California anyway. And if you're ever sued, the California court is certainly going to apply California law. So there's no real advantage at the holding company level, at the LLC level, to have an out-of-state LLC, particularly for real estate. Once you get to the holding company level, though, that analysis changes. Because at the holding company level, now we're not doing business in that state. We're holding interests in LLCs that might be doing business in a dozen states. But the asset management limited partnership itself is not going to be. So we can choose one of the better states. And the states that are considered better are Arizona, Nevada, Wyoming, Delaware, Alaska are also very good. And we use Arizona for some particular reasons, which we'll discuss a little bit later. But that's where you get a diversity of jurisdiction. So not only are you now having 2 layers of charging order protection, the first layer at the LLC level, but now you have a second layer at the holding company level. The holding company is going to be a multi-member entity. What that means is that it's going to file its own 1065 partnership tax return. It's going to be taxed as a partnership. It will not be disregarded. It will have its own separate EIN number and be taxed as a partnership, and it will generate K-1s for the members. So it is still a pass-through entity, so there is no tax assessed at the limited partnership or holding company level, but it is a pass-through entity. And so you're still going to pick up all the income or loss on your personal return. The benefit of that is that you still get all the benefits of that. So if you have a bunch of depreciation coming through from bonus, you're using bonus depreciation, you're buying real estate, it's all going to pass through on the K-1 straight to you. You still get to use it. Same way you would if you own the real estate directly. You still get the step up in basis at death because it's passed through. We haven't completed any gifts. We haven't put it in anything that would stop that. And so it works perfectly with estate planning. And as you see, it works perfectly with the asset protection trust. And that's its main goal, is to consolidate the assets.
I want to add something in here, Doug.
Sure.
Is that, you notice that we're not talking about corporations here, and we never put real estate, for example, in a corporation.
Correct.
We don't get that liabilities, the basis for the liabilities does not pass through in corporations, as corporations included. We don't get the same step up in basis if we're an S corporation. So we don't, investments we hold in the holding company is always a limited partnership. It's never even an LLC tax as an S corporation.
Never.
There's serious tax considerations. We want investments to be held through a limited partnership or an LLC taxed as a partnership.
That's right. Yeah, 1,000%. And this is a mistake I see all too often. Oftentimes clients will come and they've already done a bunch of planning and they'll have a bunch of S corps.
I will tell you, this class we had the last 3 days.
I know.
We probably had 5 or 6 people with real estate in
S corps.
An S corporation. I'm going.
I know.
It's just it's really sad when I see it.
Yeah.
It's a big mistake. So this is why when we're talking about this, when he's talking about LLCs, true, LLCs, an S corporation can be an LLC taxed as an S corporation, but we want it to be taxed as a partnership. So
yeah.
When we're talking about investment assets.